5 things as a money protection attorney I would never do, blended families edition. Thing number 1, I would never leave any money or property to my ex-spouse. Instead, I would update all of my beneficiary designations and remove my ex-spouse from being named on any of my accounts to update it to reflect my current desires. Thing number 2, I would never add my new spouse's name to the deed of property that I owned prior to this marriage. Instead, I would make sure that this property is in a revocable living trust and either name my spouse as a potential beneficiary or give my spouse lifetime right of occupancy rights should I be the one to pass first. Thing number 3, I would never leave everything to my spouse when I die. Instead, I would set up a revocable living trust where I properly funded all of my assets into my trust and at my death ensured that at least 1/2 of my property, of the community property's assets, go to my children and the other half goes to my surviving spouse. That way, my kids and my surviving spouse do not end up in court fighting over everything. Thing number 4, I would never leave anything to my spouse's children in their name when I die. Instead, I would set up a revocable living trust where I specifically name my spouse's children in my trust as potential beneficiaries, since the law does not automatically give them inheritance right to my stuff. Thing number 5, I would never list multiple children as future beneficiaries and co-owners of one primary residence. Instead, I would have a revocable living trust that holds title to my primary residence and make sure that it includes specific instructions that takes into consideration the legal, financial, and tax implications of co-owners of a primary residence.